Let's bring Blake Beckham on the show right now. Blake, welcome to the show. Thanks for being here.
Thank you, Michael. How are you today?
Oh, amazing. Things are really popping around here. Amazing. All right, you wanted to talk about arbitration today.
Well, Michael, a lot of your listeners are CEOs and business executives. They have a lot of responsibility on contracts, and there are times when arbitration agreements are good, but there are times when they're definitely not. Arbitration was primarily, the history of arbitration came from the insurance industry when the insurance companies were trying to save money and not have runaway juries and control lawyers' fees. And there was a time when arbitration was inexpensive. What has happened is that all of the apparatus for arbitration, the arbitrators, the agencies that run it, have all decided they want to make their own profit center. So if you happen to be involved in litigation, a trial at court is free. Maybe you pay, $200 in filing fees. The judge is free. You don't pay for those things. If you get into arbitration, and there'll be times when a large business and a small business are in a contract together, and the large business wants an arbitration in New York City in front of 3 arbitrators, in front of the AAA, say, a particular organization. Well, the arbitrators' fees are almost always going to be more per hour than the lawyers. There's 3 of them. I have a client that recently signed a contract that didn't realize it, but it said he had to pay all of the arbitration expenses. It wasn't split 50-50. And so we're traveling to New York. We're paying 3 guys $800 or $900 an hour, and then an agency probably the same amount, $70,000 to $80,000, to administer the arbitration. And they do nothing more than forward emails. So what started out 30, 40 years ago as a good idea has changed into a very expensive proposition. And so, you want to go into them with some strategy.
What would be a good strategy? Give us some overalls, because I've seen those legal bills come in like that. Yeah, I'm going to charge you for sending an email. I'm like, what?
Okay, so if you think you're the one going to be suing, if it's a contract that, hey, if the other side doesn't follow through, I'm going to need to go after them, you're going to want somebody to be aggressive. And arbitration really isn't a place where you can be very aggressive. It's supposed to be quicker. It's oftentimes not. But part of arbitration, the initial genesis of it, was that there would be less discovery and less paperwork and supposedly less expense. If you really want to get after somebody and prove up your damages, you're going to want to have access to depositions. You're going to want to have access to documents, and the arbitrator may allow that or may not. A judge typically always would. So if you're going to be the plaintiff and you're going after someone, you'd probably rather not be in arbitration. If you're a big company that doesn't mind spending money and you want to make somebody chase you in a different state, there were some clauses. One time a company tried to have all the arbitrations held in Guam. Well, that eventually got struck down. Okay. But big companies, especially with consumer products, if you buy a software package nowadays, there's a piece of paper inside of it that you never see that says you agree to arbitration and you can't have a class action arbitration. Lots of abuses in how arbitration contracts come into existence, and the big companies really have an unfair advantage there. But on the pros and cons side, if you're going to be the defendant and you think you're going to be sued, and you're concerned about a jury that might really go off on you or your company, or you're in an unpopular industry, arbitration contract might be great for you. Now, as a businessman dealing with a stockbroker, dealing with a realtor, oftentimes those contracts will have an arbitration that's within a trade group. So if you want to sue your stockbroker, there's going to be a set of arbitrators that that's all they do, and that typically favors the defense, favors the industry side as opposed to the person that's filing the suit. So, it's always a great idea if you are negotiating a contract and there is an arbitration provision, the other side's asking for an arbitration. Talk to, in addition to whoever your lawyer is reviewing the contract, talk to somebody that handles trials and arbitrations. The transactional lawyer is going to say, yeah, it looks fine, I understand what it says, but he or she is not going to have the depth to tell you, gosh, in this context, you would probably rather be in litigation. I tend to rather be in litigation. I like to be aggressive. I like to have appellate rights if possible. When you arbitrate, those rights are gone. The arbitrator makes a decision, and you're stuck with that forevermore. So arbitration is something that started in a limited context. It became more popular, but it also has gotten out of hand with the amount of people that are making a living administering it, running it, being the arbitrators. They've all realized, hey, we can raise our rates to whatever we want. A lawyer's going to have pressure and pushback from his client, but the arbitrator's the judge. How are you going to argue with him on his fees? That makes sense?
Yes, absolutely. That almost falls in the ambush segment,
Yes.
It's a trial by ambush. Is that what?
Well, trial by ambush would be something that is more likely to happen in arbitration. If an arbitrator says you're not going to get a lot of discovery, you're not going to get depositions, then the witness on the other side, you hope you're getting the truth out of them. Maybe you're not, but an arbitrator can't hold somebody in contempt of court. An arbitrator can't rule somebody has committed perjury. So that the people will try to get away with more. You're in a conference room in an office building somewhere instead of sitting on a seat with a judge and a court reporter sitting right there. So the formality of court heightens the seriousness of the matter, tends to have the ability to show people not telling the truth more easily. Arbitration, people will try to get away with more. And if there's no discovery, which is depositions and documents, you're going to have a trial by ambush, and it's whatever they want to say versus whatever you want to say, and there's no acid to test it beforehand.
I get it. So takeaway message is always have the litigating attorney, go through whatever it is you're going to do and make sure that you have some discovery before you get into the arbitration
That's right.
room. Okay.
Or make the decision, I don't want to do arbitration, and take it out of the contract. There's times when it serves a purpose, there's no doubt. But just to think, hey, I'll never have an argument, so that arbitration clause doesn't bother me. If you took the same argument, I'm never going to get in a fight with this guy, so why have a contract?
Right.
The reason to have a contract is to protect your rights. The reason to have the right to trial or arbitration is also protect your rights, and you need to be just as careful with the arbitration term as you do, or not, as you do with the rest of the contract.
Yeah, I know that this is a mile-long subject, but Blake, thank you very much for clearing the air on this one. It was a great help to me. Appreciate it.
Okay, Michael, thank you. Have a good week.
My pleasure. Blake Beckman, founder and president, the Beckman Group, BECKHAM group, GROUP.com. All right, we're going to go to a break right now. Segment brought to you by the Beckham Group. And when we come back, we're going to come back with Ed Baxter, Private Equity Spotlight, for an extended interview on Ed's topics today. We'll be right back. You can listen to CEO Money with Michael Yorba, segment brought to you by the Beckham Group.